I'm the purchaser of undivided interest of two sharers of
Purchase. Purchase. When is the purchase?
1990, my lord, I have purchased. I have present appeal is filed against the preliminary decree passed by the partition in a partition suit. Appellant is an alienee during pendency of the suit.
A party who has not questioned a preliminary decree, can you pass a final decree?
My submission would be, there would be that is an arguable point, no pending in many matters before your lordships. A preliminary decree is a decree passed by the court declaring entitlement of the shareholders only, which is nothing to do with the purchaser or somebody third parties are concerned. So far as share determined in the preliminary decree, so far as my vendors are also concerned, there is no dispute at all.
What I want to know is, in this, whether the sale deed, whether the sale transaction that is entered into between you and one of the co-partners, unless and until court says that that is so and so, and such a finding is not given in execution proceedings, what is the execution court to be do?
My lord, my submission is, my lord, my vendor have got a share of 1/3 share in the property. I have purchased the entire property belonging to the family. Now, my lord, I was not made as a party, or I was made as a party in the suit. It is a different aspect. In a final decree proceedings, my lord, if I am not made as a party, if I go and tell the court that my vendor have got 1/3 share as determined by the civil court, I am entitled for that while affecting equitable partition by the FDP court. That is the main function of the court is concerned. My lord, while exercising this power, what the things to be bear in mind of the court, FDP court is, it should not deviate from the decree which is a preliminary decree is concerned. Suppose I went to the executive FDP court saying that, you see, there is a preliminary decree in which 7 shares have been divided into between 7 members. I am the purchaser from members A and B. Their share I am entitled to seek allotment in my favor, and they are also have no grievance whatsoever. That's all the things I went to the executing court, the FDP court. The FDP court says, since I have already passed a final decree, I do not want to reopen it.
After the final preliminary decree is passed, whoever comes before the final, before in the final decree proceedings, the court keeps on adjudicating which
it is not like that.
It's not property to be allotted.
Not whoever he wants. A person who claiming a right.
Who purchased the property in the year after the suit is decreed.
My lord, my submission is, that's what I wanted to contend. So far as a partition suit is concerned.
Then claim it from your vendor. Why should the final decree proceedings be open? No, you are entitled for a share from your vendor.
No, I will come to that. No. A separate suit to that extent would not be advisable. Would not be advisable. I am not on that merit of the matter. Just look at me and hear me. Very small question I wanted to raise. I want a very small relief. Though I am a senior counsel, I take it from him, my lord, in a lighter way I wanted to. That's only the small relief. I may get, I may not get. It's a different aspect. It's an adjudication to be made by the FDP court. They may say, no sir, we will demarcate the share of your vendor. You can recover property from your vendor. I can follow that advice. No, we have not reached to that stage. My Lord, the petitioner's father, Krishnappa, had purchased a family property. It's an undivided share from one of the sharer of the family. It's under a registered sale deed. Then, my lord, the partition suit was filed without impleading us. Then suit came to be decreed. Then, my lord,
you are also a member of the joint family.
I'm not a member of the family. I'm the purchaser.
Undivided share.
Yes, I'm the purchaser of undivided interest of two sharers of
purchase.
Purchase.
When is the purchase?
1990, my lord, I have purchased. I have produced the sale deed. Lordship may kindly say I purchased the property.
Suit.
Bigger lordship.
Suit. When is the
suit? Suit is, my lord, 89, 74 of 1989.
74 of
1989.
You pending suit you purchased?
Yes, of course. Purchase in during pendency of the suit I purchased.
Yes.
Let the partition suit, it makes no difference.
So suit
because I'm entitled for share of my vendor, that's all.
is decreed.
A suit is decreed.
When?
Then, my lord, the suit was decreed on, my lord, the 1989 it was decreed.
Same year it is decreed.
Yes, 1989 it was decreed.
So
Then-
even as on the day the decree is passed, that day also you have not purchased the
I was not there. Then, my lord, FDP was filed in 1994. FDP 8 of 1994. 1994. My sale deed was 3/5/1990. Then, my lord, when the FDP was pending, I came to this honorable court in second appeal, challenging the judgment passed by the trial court in both preliminary decrees are concerned. This honorable court, my lord, upon examining the matter, passed an order. Your lordship will see that order, my lord, I have produced at page 32, annexure C, my lord, in second appeal. My father Krishnappa was before this court.
Page 32.
32, annexure C. May kindly go to page 33, my lord. The present appeal is filed against the preliminary decree passed by the partition in a partition suit. Appellant is an alignee during pendency of the suit. Appellant is placed ex parte in the suit. However, the final decree proceeding, the appellant was participated.
So
It
what
is
is
said-
this appellant is placed ex parte in the suit? What is that? First line it says appellant is an alien during the
Alignee, anyhow, that we will, that fact may not be so relevant. What
when
is
you
the relevant fact is, this honorable court granted me a liberty to challenge the final decree if it is passed. That was the second appeal observation. They wanted to encash that, that's all. The appellant has participated. It is said that final decree is drawn up. As alignee is inappropriate for the appellant to work out his remedy for equitable partition seeking allotment of vendor's
So a
share.
party who has not questioned a preliminary decree, can he pass a final decree?
That-
Can he
that-
question a
that-
final decree?
Why my submission would be, there would be a, that is an arguable point, no pending in many matters before your lordships. A preliminary decree is a decree passed by the court declaring entitlement of the shareholders only, which is nothing to do with the purchaser or somebody, third parties are concerned. If there is a unsatisfaction by any person in the family about a share and other thing, they could challenge an appeal before the regular appeal under section 96, then before this honorable court in second appeal. So far as a purchaser is concerned, that restriction provided under section 97 of CPC would not be applicable. It's an argument we wanted to address. To that extent, some matters are entertained which are pending before you were
No,
this
on
honorable.
an academic this thing.
Yes,
Now, whatever is a preliminary decree, in a
Correct.
final decree, it would be executed looking at
correct,
other.
correct.
So,
Correct.
in a final decree, court would not be deciding the entitlement of the parties.
No, I'm not asking for,
only
nobody is,
decide
nobody.
That's what.
No, now,
By virtue of this, the
so
court has
far as share determined in the preliminary decree, so far as my vendors are also concerned, there is no dispute at all.
No,
Correct.
whether such a, no, for example, you have purchased the property from A. Now A has two sons or whatever or the legal heirs. They say that particular sale, what has been done by A, is not in the joint family interest or not for the joint family necessities. So such a sale is not binding on.
That is a different aspect of the matter.
Unless and until
That could be adjudicated by the civil court, that will be adjudicated if such a situation arises. That could not be also decided in FDP. Suppose a decree, yes, he has to file a suit, the decree is not binding or sale deed is void. All those things open for another family member whose right is under prejudiced. He have a right to that. I am not on that point.
What I want to know is, in this, whether the sale deed, whether the sale transaction that is entered into between you and one of the co-partners, unless and until court says that that is so and so, and such a finding is not given. In execution proceedings, what is the execution court to be do?
My lord,
to
my
have to-
submission is, we were before the FDP proceedings. There's a judgment of the Supreme Court says, in FDP proceedings, in addition to the other issues, which is consequential incidentally coming up before the FDP court is empowered to adjudicate that.
There are certain section
Yes,
47
certain
and
contingencies,
other,
sir. For
contingencies.
example, I would like to put it in this way. My lord, my vendor have got a share of 1/3 share in the property. I have purchased the entire property belonging to the family. Now, my lord, I was not made as a party, or I was made as a party in the suit. It is a different aspect. In a final decree proceedings, my lord, if I am not made as a party, if I go and tell the court that my vendor have got 1/3 share as determined by the civil court, I am entitled for that while affecting equitable partition by the FDP court. That is the main function of the court is concerned. In that way, it would not given a room that a final decree court may deviate from the preliminary, that question would not arise.
Do you have a citation which says any?
Yes, my lord, I extracted the citation, may kindly go to page, my lord,
A citation
2009 SCC.
citation which says that a party who has purchased the property subsequent to the partition decree, preliminary decree, and who has not questioned such a decree, or who has not pleaded himself, his rights can be determined in a final decree proceedings.
Thus, the application for final decree, as and when made considered to be an application, is a pending suit for granting relief of division by metes and bounds. This is the law. Ultimately, we knocked the doors of final decree court. We said we have purchased some share of some of the family members. Under the preliminary decree, their extent of share have been declared. Please allow us to participate in the proceedings. My lord, keeping us, when there is a decree for 1/7 share, final decree passed only allotting a share of only one sharer, and without affecting the partition by metes and bounds of other 6 sharers are concerned. That's the stage, my lord. We, thereafter, a execution petition was filed by the party who got a final decree in her favor to execute the decree for the purpose of dispossessing the persons who are in possession of their respective shares are concerned, alleging we are the encroachers of theirs as determined in the preliminary decree and final decree proceeding. When delivery warrant was issued, this petitioner, that my lord the purchaser, had approached this honorable court, knocked the doors of this honorable court for their indulgence. This honorable court granted interim order. At the later stage, writ petition came to be disposed of, saying that since the time stipulated to execute the delivery warrant have been spent on its own, writ petition would not become survive. Therefore, if you have got any other remedy, you can go and approach the FDP court. That was the observation made by this honorable court. Taking advantage of that order, including the observations made by this honorable court in second appeal in earlier round of litigation, I went to the executive FDP court saying that, you see, there is a preliminary decree in which 7 shares have been divided into between 7 members. I am the purchaser from members A and B. Their share I am entitled to seek allotment in my favor, and they are also have no grievance whatsoever. That's all the things I went to the executing court, the FDP court. The FDP court says, since I have already passed a final decree, I do not want to reopen it. This was the order passed by the FDP court. That order is, my lord, impugned in the present date. In the sure. I will tell you to take your seat. Then what happened was, then, my lord, we challenged this order here when the writ petition is pending. Another purchaser of another share by the another family member have also filed an application before the FDP court to reopening of the FDP enabled to adjudicate his grievance. Now that application came to be allowed and FDP proceedings are reopened. Now FDP proceedings are pending. This is the intervening development which have taken place.
Where is that order?
That I wanted to. That's the reason I wanted to file a memo. This is the memo we wanted to.
Now
file.
after the final preliminary decree is passed, whoever comes before the final, before in the final decree proceedings, the court keeps on adjudicating which
It is
property
not
to
like that.
which
Not,
property to be allotted to whom.
not whoever he wants. A person
But
who
to
claiming
a
a
party
right.
who purchased the property in the
Yes.
year after the suit is decreed.
My submission is that's what I wanted to contend. So far as a partition suit is
Then
concerned,
claim it from your vendor. Why should the final decree proceedings be open?
Milord,
No, you are entitled for a share from your vendor.
no,
You're
I will
entitled
come
for a share
to
from
that.
your vendor.
No. A separate suit to
Yes.
that extent would not be advisable. Would not be advisable. Anyhow, Milord, now I wanted a very small relief by this honorable court, taking note of intervening development. I filed a memo. May I read that memo for a moment?
Where is that order that it is reopened?
The entire order sheet.
No, there must be an order that there must be an application and an order.
Milord, on Geeta, Sujata and Pushpavati, they are the petitioners. They filed an application for reopening of the proceedings.
When it happened?
The proceedings is reopened at their instance.
Where is that? Where we get that? Some application is filed under section 47 of CPC.
Yes.
Why they have filed a 47 CPC petition?
Milord, they want share to be allotted to
And
them
that we will
towards
see.
of their vendor.
Yes.
Yes. Milord, I am not on that merit of the matter. Just look at me and hear me. Very small question I wanted to raise. I want a very small relief, though I am a senior counsel. I take it from me, my lord, in a lighter way I wanted to. Now, anyhow, it is not in dispute at the instance of some persons who are similarly situated with me. They made an application, FTP proceedings are revoked. So far as me is concerned, when I sought for similar relief, that was declined. Now I am neither here nor there. Therefore, a memo I have filed.
Under which provision of law a petition is filed by this petition?
Order 20 Rule 18, my lord, we made an application and read with section 151 of CPC. May I read the memo, my lord, may kindly be seen?
Yes.
It is submitted that the petitioner in this petition calling in question the legality and correctness of the order passed by the learned senior civil judge JMSC Sidligata dated 19/6/18 in miscellaneous 2 of 2018. Said miscellaneous petition 2 was filed under section 151 and read order 20 Rule 18, wherein sought for reopening of the FTP proceedings enabling to identify, demarcate share of his vendors who are the parties to the preliminary decree, where there are share also declared therein. The said miscellaneous application came to be rejected by the learned senior civil judge JMSC dated 19/6/2018. In the meantime, FTP was reopened at the instance of the application filed by some of the sharers, whose sharers have been declared under preliminary decree in OS 74 of 1989. Thereupon, the commissioner was appointed to demarcate the hands parties in their terms entitlement under preliminary decree. Commissioner appointed to that effect was conducted the survey, who submitted the report, wherein property purchased by vendors herein are identified in the name of vendor so-and-so, who are parties to so-and-so. Since the final decree proceedings are already been reopened and it is in progress, may kindly see next page.
Yes.
Progress, wherein the petitioner is also respondent number 7 therein, reserving liberty to the petitioner to work out remedy in the pending proceeding and this writ petition may be disposed. That's only the small relief. I may get, I may not get, it's a different aspect. It's an adjudication to be made by the FTP court. They may say, no, sir, we will demarcate the share of your vendor. You can recover property from your vendor. I can follow that advice. No, we have not reached to that stage. My submission is, I am similarly situated other person. Where do we reopen the proceedings? In my case, you said no. Now I am neither here nor there. Give me a liberty. I will go and tell them this is the property I purchased. I am entitled for her share. It was the sale deed. You adjudicated. That the court can say yes or no. If they say yes, I convey my thanks to the court. If they say no, I will come to this honorable court, knock the doors of your lordship. That's all the limited grievance I wanted to put. That is the reason this memo is filed.
Please come.